So good afternoon and welcome everyone to Contracts for Nonprofits and Small Businesses. I want to first thank our co-hosts, Saint-Gobain and Holland Knight, for helping us put together this hybrid event. My name is Evie Cruz, the Nonprofit and Small Business Coordinator at Philadelphia VIP, which is an organization that connects low-income Philadelphians to free legal assistance from volunteer attorneys at law firms and corporations across the greater Philadelphia area. As you can see, we have, if you go to our next slide, please. We have four main priority areas at Philadelphia VIP, and my focus is community economic development. Now, before I pass things over to our presenters for the day, I just wanted to remind everyone joining us virtually that we are saving questions until after the presentation. So you can either submit them to me through the chat function or use the raise hand option under the reactions button at the bottom of your Zoom window so I can call on you after the presentation. So please stay muted for now. Following today's workshop, I will be following up with those of you who indicated that you would like to meet with an attorney one-on-one to address a specific contract issue you have for your business. Here in the next slide, you'll see our basic eligibility criteria for our program, which is also stated on our website. I will put a link in the chat right now to the page where you can access our small business and nonprofit applications, but of course I will be following up with you all individually. So don't feel like you have to grab it right this second. Let's put that in there. Okay, and so now I will turn things over to Paul Jaskett from Holland Knight, who will introduce our presenters for the day and get us started. Thank you, Paul.
All right. Thank you, Evie. Good afternoon, everybody. It's my pleasure to welcome you virtually and in person to Holland Knight here in Philadelphia. It gives me even greater pleasure to introduce our panel today. First up are Latoya Hackney and Janaki Catanzariti from Saint-Gobain Corporation. Latoya is the Senior Vice President and General Counsel and Secretary of Saint-Gobain North America, and Janaki is Division Counsel in North America. Saint-Gobain, many of you may know, is a worldwide leader in light sustainable construction. And they design, manufacture, and distribute materials for the construction and industrial markets. Next time you're driving around Philadelphia and you see all the great construction out there and you see the name CertainTeed wrapped around a house, that is just one little sliver of what this great company does across the world for its customers and its markets. And they are guided by the principle, as noted, that they want to make the world, or they are making the world, a better home. Next slide, please. As far as Holland Knight goes, we are a global law firm with offices in probably 28 cities right now. We opened our office here in 2018 and are thrilled to, many of us came from other law firms in the area. We were thrilled to establish a Holland Knight office here. I'm even prouder to say, aside from the legal work we do for our clients, our great clients like Saint-Gobain, we also are committed to the community through a very well-recognized pro bono service and community responsibility program across the United States. I'm Paul Jaskott. I'm a corporate attorney, been practicing law here in Philadelphia for the past 27 years. I'm a South Philadelphia native, very proud of that. And I'm joined by my colleague, Mallory Eisenbry, who is working with us for the summer and who is currently a law student at Temple University. So our objectives for today, we would like our audience to understand what contracts are. Some folks think they know what makes a contract, but we're going to give you a primer so that you understand when you are entering into contracts, or where you think you're not entering into contracts, but you may accidentally do that. We also want you to know how they're used and how we think about them as lawyers and how you should think about them in your business. We're going to do a review of contracts that are commonly used by your companies, the companies that are the focus of VIP Small Business Program, nonprofits, and other small businesses. And we're going to discuss some drafting basics and learn how contracts work in practice. In other words, what we hope to do here is not talk to you like lawyers, but talk to you as just, the business people that you are, wanting to learn more about how contracts can help you achieve your strategic goals for your business, no matter what that may be. So with that, here are some contract basics, and I'm going to turn that over to Janicki.
Thank you, Paul.
Yep.
And thank you, VIP, Philadelphia VIP, for having us here. Natura, do you want to give some opening comments on Saint-Gobain's behalf before I take over contract?
Well, thank you, Janicki. We are thrilled to be here. As Paul mentioned, our purpose is making the world a better home. And within our law department, we certainly try to exemplify those principles and the principles in terms of corporate social responsibility. And that's one of the reasons that we are partnering with Philly VIP to help bring our law department together and provide valuable resources to the community here in Philadelphia, some areas of which may be underprivileged. I think there can sometimes be a sentiment when you're just getting started in a nonprofit or a small business. You may think that you don't need sophisticated legal advice. You may think that you don't need in-depth contracts, but certainly there's certain high-level principles that can be of assistance to you as you're building your business and as you're building out your nonprofit. So that's what we're going to get into today. And I also want to just give a special recognition to Janicki, as this is our first pro bono project as an in-house law department. And so we're honored to really partner with Philly VIP and with Holland Knight on what is our inaugural pro bono
Yes,
event, which
absolutely.
Janicki had a significant hand in organizing.
Thank you. All right, so contracts. It's a scary word for most people who don't work in the world of contracts. We lawyers do a lot of that. And I think a lot of that stems from the fact that there is legal English in these contracts. They're difficult to read, and there is a fear factor as to what they say. And so we don't understand every aspect of it. The really important part about today's presentation is giving you those little sound bites for you to keep in mind when you're working on your contracts, and to be able to use them when you're dealing with your vendors, with your customers, with your landlords, or even if you're seeking employment, right? So what contract is really very simple in its definition. It is an offer, it's an acceptance, which has a consideration. So what would you think about it as? It's like you offer your hand to shake hands with someone, the other person accepts your hand and shakes it back. So you have a handshake. So this is kind of a oral agreement kinds, right? But it's not an agreement you can enforce because there is no give and take of something. So the give and take that you have is the consideration, and that's what makes your contract a contract, right? You can have an oral contract, you could have a written contract, it can take any form, but once you have a contract, it's binding. Why do we prefer a written contract over an oral contract? It's easier to prove. It's not he said, she said. It is really something you put into a document and you sign that, right? But the tricky part about reading a contract is understanding some of the terms there that shout out at you, and you're thinking, oh my God, I don't understand this, so I don't want to read this. For some of our clients who I work with closely, the biggest fear factor is reading a document that has all these terms in there. And so they're not ready to really dig into it and understand it. Why do you need to understand your contract? You need to understand your contract because you have to live with it. It's a living document. It symbolizes your relationship with someone else. It puts together the terms under which you're going to work with them. And if you don't understand those terms, you're not going to be able to work with them or enforce them. So the good part about it is read your contracts, leave the fear aside, try to muddle through them. And over time, you'll start getting used to the language as well. Okay. So what are the key words that we lawyers work with? We work with reps and warranties, covenants, damages, exhibits, indemnification, and boilerplate, right? For you and me, before I went to law school, this meant nothing, right? These were just words, and they were pretty scary. But reps and warranties are really what you're warranting, or what you're telling the person you're getting into a contract with. In this point of time today, what I am saying is correct, right? And based on what I'm saying, you may rely on my word and get into a contract with me. So the reliance factor on the representation is very high when it comes into contracts, because if you lie, if you are not truthful, it's a misrepresentation, and that can get you into litigation. So you want to be careful that your contracts are always saying taking the right position upfront. Covenants, well, covenants to me is a very tricky word, right? I mean, it really is an agreement. So we're talking about contracts, which are agreements, and then you have this word thrown in there, covenants, right? And after reading a lot about this, to me, it really is another word for an old-fashioned agreement. An old-fashioned agreement, which doesn't require really a consideration. It is just on human spiritual pledging of take my word for it. Trust me, I am telling you the right thing, right? So these are covenants. You don't see that word typically in most of the contracts you may be dealing with on vendor or service, but you will see them if you're talking about ownership agreements between parties. You will see those kind of words. If you're talking about leases, you will see that word covenant. Just know it simply means an agreement, right? Something you're agreeing to do or not to do, and you're taking the onus on yourself. Damages is a remedy. It is not what you agree or don't agree. It's a remedy that you agree to give somebody should you not fulfill your agreement or your obligations under the contract. It is also a remedy that you have if your counterpart doesn't fulfill its obligations, right? So damages is really the section that you may want to focus on if you feel like your relationship is not going to always withstand the test of time, okay? Exhibits, you will see sometimes a lot of exhibits, appendices get attached to a contract. That is really an extension of a contract. So you don't want to make the contract too wordy. You put it at the back so it's easier to handle and manipulate, okay? Indemnification is really one of the remedies, again, under a contract. And what indemnification does is it allows you to get paid for any loss that you may incur if your counterparty does not do what they're supposed to do under the contract. So it's a form or a means of assigning responsibility for the damages that you can claim, right? And boilerplate, all of us work in the digital world, right? All of us do. Everybody, all of us click something, accept terms on your apps or whatever it is that we work on our phones or on our laptops. Those are all boilerplates. And there's a whole host of laws out there about boilerplates, whether they are enforceable, whether they're not. But typically, you do this every day of your life today. All of us who play with our iPhones or our Androids, we are clicking on something that's a boilerplate, right? Yes, sir.
Mind if I jump in for a minute?
Please jump.
So hearing that wonderful explanation from Janet of these different terms, I thought it might be helpful just for a minute to maybe go through just a few simple examples of how this might all work together, okay? So a representation, as Janaki said, is a statement about your business currently. So for example, in a contract, there might be a statement in there that says, I, company A, am in compliance with all laws that apply to me. Okay? There might be a covenant, which is an agreement or a promise, in which you say, and going forward, from this day forward, I will be in compliance with all the laws that are applicable to me. There might be an exhibit, like a pricing schedule, that says, for doing these services, I'm going to pay you a certain amount of money. Okay? So that's all that makes up the body of the agreement. But what happens if somebody doesn't do what they said they were going to do, whether it's complying with a law, or whether it's paying you the money you're owed, or whether someone made a statement about their business that turned out not to be true, that you violated the law in the past? Then you go to indemnification, which is that remedy that was discussed, and you say, hey, you're supposed to indemnify me because you promised me these things, you said these things, and they're not true. And then, because you're supposed to indemnify me, I'm entitled to damages. I'm entitled to the amount of dollars that I have lost or I can't obtain because you didn't do what you said to do underneath this contract. And how do I let people know that? Because in the boilerplate, there's many things back there including things that say have a notice provision where you are required to send a certain type of notice to a person, letting them know that they're in breach of contract. So anyway, that's, a relatively simple example of how all these different terms might be woven together into a contract that you're working on.
So what are the different kinds of contracts you would typically see in your day-to-day operations of your business, right? We all buy something for our business. We all sell something from our business, whether it's a product or whether it's a service. Sometimes we have to lease premises to work from. We employ people or get employed ourselves, right? And we sometimes have partnerships. So the kind of contracts that you have are vendor contracts where we actually buy something from someone. We have commercial leases, which are leases for our offices. Employment agreements. Sometimes you don't really need an agreement for employment. You can have a letter, an offer letter that becomes a formal agreement. But for things like commercial leases or vendor agreements or service agreement where you're buying a service or you're selling a service, you do need definitive agreements because they are going to be the framework of your relationship, right? And now we also have certain particular contracts for nonprofits, which are specific to them about raising funds and figuring out how not to lose their nonprofit status. So we are going to go a little bit into these agreements as we go along. But most commonly in a day-to-day business, you're going to be working with purchase orders. You're going to issue a purchase order and you're going to issue an invoice, right? So it's purchase orders and invoice. And all of these purchase orders and invoices have terms and conditions that are set in very fine print behind that paper or in another attachment, right? And it is that fine print that's going to govern your arrangement on the price and the volumes that you've already agreed on the front page. So you have the front page, which is commercial, and then you have this fine print. Don't ignore that fine print because that fine print is a contract. When you exchange purchase orders and exchange invoices, you're signing something, or even if you don't, it is an implied contract because it's an exchange. Now, this law on purchase orders changes from state to state, right? Some states follow what is the common law, where the invoice terms are the last terms in, so they may govern. A lot of states follow the Uniform Commercial Code, and that applies that says the purchase order terms and conditions govern. Of course, for service contracts, the Uniform Commercial Code does not apply, right? So even if you feel that it is a printed form, make sure you read it, understand the risks based on the terms that we've just spoken about a little bit, and see whether you're comfortable with the terms that you're getting from the other side, right? So one of the questions that I get asked often is a purchase order a contract, right? Because it's a purchase order. It doesn't look like a contract. It's a simple piece of paper. But yes, it is. Once that purchase order is issued and you accept that purchase order, it becomes a contract. So it is a contract. The other question that we get asked often is, what are the governing terms? If I give a PO with my terms and conditions and someone else gives me an invoice with theirs, whose terms and conditions will govern, right? Because they're two. This is where it is the classic battle of the forms in real life, right? Whose terms govern? And there's lots of case law out there. So it all depends on whether your state is a common law state or whether it is a Uniform Commercial Code state, right? But even if that is the case, there is no black and white about it. That's the gray area of purchase orders. Because if you can show a fact pattern that the other side wanted to accept your terms or has agreed to accept your terms through emails or whatever that fact may be, you can argue that my terms and conditions govern, right? So because they're pre-printed, can we negotiate them? Absolutely. Just because they're written behind on a piece of paper doesn't mean you have to accept them. You can read them, you can ask for them to be changed, you can have a small letter agreement that says these terms and conditions are amended with these are new terms and conditions. So don't be afraid to go out there and ask to change something. Don't feel like, oh my God, I don't want to read it because it's not going to change anyway. What's the point, right? It's not a game of an ostrich. We want to understand what we're getting into for everything. And you can also cancel a purchase order, right? You can cancel it even if it's a contract. Why would you cancel it? You would be breaching it. But we have to park that thought for a moment till we come to the end of this presentation to understand how you have to hedge your bets when it comes to certain contracts and in your day-to-day life to run your business, right? Victoria?
Sure. Thanks, Janaki. So we're going to get into vendor contracts, but before we jump into this, just be mindful. I don't think any organizations need to be fearful about contracts. The thing to be is careful, right? There can be fear and intimidation in some of the language used, but today we're giving you sort of tips and pointers to help you be really careful. Vendor contracts, they're so important because they go to the relationship you have with organizations, other businesses from which you would be buying services, right? So you may be a vendor providing services, but you could very well, whether you're a small business or a nonprofit, be procuring or purchasing goods or services. So let's move to the different types of vendor contracts. So we see 5 categories here. I think in the interest of time, I'll focus on the ones that you're most likely to see. So the first is a fixed price contract, which is exactly as it sounds, right? The buyer pays a lump sum, a fixed amount. That amount is spelled out in the terms or the wording of the contract. And it spells out also, the resources, the time that'll be put in, but upfront what the pricing is going to be. You'll also, perhaps from time to time, see time and materials contracts. And a time and materials contract goes to an hourly rate plus the cost of whatever materials that vendor or contractor may be using. And then finally, in unit price contracts, that goes to the cost per item of the actual thing or things that you're procuring. So in terms of some basic questions around vendor contracts, you want to ask yourself, okay, what are the deliverables? And what is a deliverable? It's the thing, the item, the service, whatever it is, right, that's being provided or delivered. So you want to think about what condition is it going to be in? Is this vendor using new materials? Are they allowed to use used materials? And does that make it cheaper? Depending on your nonprofit or business, would you be in compliance with applicable laws if you allowed your vendor to use used materials, right? So really thinking through what this vendor is going to do. The duration of the contract. So lawyers refer to that as the term. Basically, how long is the contract going to run? What's the expiration date? And when the contract expires, will it automatically renew? You see some contracts that will continue automatically. That's called evergreening, unless you give notice. Maybe it's 30 days, maybe it's 60 days that the contract will terminate. But you want to know what's being delivered and in what condition and how long is the contract. Janaki talked earlier about a legal term called consideration, but that's really the payment. How much is it going to cost? When is the payment due? And what's the method of payment? How can you pay? If you're a small business just getting started or you're a nonprofit, you need to be thinking about your cash flow. There could be something that you need. Do you have all the money up front? Maybe you don't. Maybe you want to set it out in certain payment terms. Maybe you sign a contract and you don't want to pay for 2 months, right? Those details of the payment, when it's due, how it's due, need to be spelled out. And the reason why is that if you don't meet those terms, then you could be in breach or default. And then that takes you back into some of the things that Paul was talking about in terms of damages and remedies, and that Janaki touched upon also. And in terms of terminating the contract, what are the conditions where you can walk away? So we just talked about earlier, we talked about duration or the term, right? That's how long it is. That's sort of the natural ending point of the contract, the date that's set in there for termination. But what if you have a vendor that's not performing? What if your conditions change and you're unable to pay? What if your business changes and you still need the item or the items or the services, but just not as much, right? Or what if you need more, right? So all of these things you should be thinking about in terms of terminating a contract, how you walk away, and to Paul's point earlier about how disagreements will get resolved. So what are some other things to think about? Privacy and cybersecurity, right? The security of data. If you're exchanging data electronically, making sure that the vendor has the appropriate safeguards in place and appropriate insurance in place. Exclusivity provisions. What does this mean? What the vendor is doing for you. Is this a specialized service? Is there some special sauce that they're using only for you? Or is this a service that they typically offer to lots of other entities? So you need to be thinking about that. This is also important to the extent that you could be sharing confidential information with them that they are then incorporating into their processes or what they're making or what they're building. So you should be thinking about that. And if they're using that information and selling it to others, then you may want to think about, should you be gaining from that financially, right? Yourself, should you be getting something called a royalty if they're using your information? So those are some of the other complexities that can come into it. Limitations on liability. It's likely that the vendor will want these from you. The vendor is going to want to say, and all this means is, if I mess up, you can only come after me up to X amount. Typically, what that means is they will try to limit what you can get back from them. If they do something wrong, they want to limit it to the amount that you paid them under the contract, right? Typically, they won't want to say, sure, I'll give you $1 million if I mess up, right? Or sure, I'll pay a penalty if I mess up. And then finally, training obligations. Depending on what kind of service is being provided, do you have an obligation towards them? Or if they're working with people on your team, do they have an obligation to provide training for you, your employees, your volunteers? So these are all things to think about. So vendor contract best practices. So I'm sure many of you are familiar with the term bids or bidding, right? So when you're going out to select a vendor, it's important not to just look at one, not to take the first price or the first set of terms, right? Typically, you want to request a proposal, and it can be simple. It doesn't have to be complex. But you do want to shop around. So check with 2 or 3 vendors, get some proposals. That way, the pricing and the terms that you're agreeing to, you get a better understanding of what's standard for the market or the materials or the services you're buying. Trust but verify. A vendor can put together a beautiful offer, a beautiful response to a bid. They can dazzle you with stories. They can try and do their research and learn more about you to get comfortable with you and make you comfortable on a personal level and make you excited to work with them. But you have to verify that they can actually do what they're promising you they can do in the contract. That means doing your online research, right, about them and their company. And it also means checking with some references, right? Maybe you give a call or 2 to other people that they have worked with or other companies that they've worked with. And you want to make sure these are legitimate people they've worked with, not just their cousin or their buddy right? That they're giving you the number to. And of course, when in doubt, you can always consult your friendly neighborhood lawyers. And now for commercial leases.
So if you run a brick and mortar business, there's a good chance that you've entered a commercial lease with a landlord. And we want to talk for a little bit about some of the specialized terms or considerations that you'd want to take into account when entering a lease like this, or if you're planning on entering one in the future. First, and probably the most obvious, is the cost. You probably have a budget for how much you want to pay in rent to your landlord. And one thing to know about commercial leases is that there might be different costs that you wouldn't necessarily expect to find in a residential lease. So in addition to whatever the base rent is, you might be expected to pay maintenance fees for common areas or different HVAC fees, utilities, water, other such things that might add to the cost of that rent. You'll also want to look at the square footage. And of course, this depends on your understanding of how much space your business is going to require. But you might see some terms in a commercial lease like gross square footage or usable square footage. And these have specialized meanings. Gross square footage typically excludes common areas or if there's a lobby or an outdoor space, that will not be included in gross square footage. And then usable square feet similarly generally refers to space that's used exclusively by the tenant. We've talked about the term of the lease or the duration of the lease. This is also something that's important to consider. You'll want to think about your business needs. Do you anticipate growing, or do you want to enter a lease that's maybe a slightly longer term than you would typically find in a residential lease? And in the event that it is a longer lease for your commercial lease, you might want to look into terms like assignments, or are you able to sublet that lease if you later want to get out of it? And finally, you'll want to consider if there's any special business or special building rules that might impact your business. So oftentimes in a strip mall, for instance, there might be limitations on the types of businesses that can operate, and these can be very landlord specific and depending on the other tenants that are in the strip mall. There also might be special rules like the business cannot create offensive odors. And even if you don't think that would impact your business, if you're a bakery or a restaurant of some sort, that might be something to consider and ask about. You also might want to consider asking about parking, security, and other modifications, who's responsible for modifications and security if you decide you need to update those things. And when in doubt, just talk to your landlord, see if you can negotiate better terms, which leads me to my next slide, talking about some other key differences between commercial and residential leases. So I mentioned the duration. It's important to note that in commercial leases, the duration tends to be much longer. When you enter a residential lease for your apartment or what have you, it's usually a year or maybe even month by month. But for commercial leases, it's much more typical to have 5 or even 10-year leases, just depending on the market and the space that you're planning to occupy. Another major difference is that there may be many fewer legal protections for commercial tenants than there are for residential tenants. So a residential tenant, for instance, when you get a new apartment, you have what's called an implied warranty of habitability, which basically means you're going to get a safe and livable space to live in because it's your home, basically. Those sorts of protections don't necessarily apply to commercial leases because courts and the law tends to assume you're two sophisticated business people, you're entering a lease together, you don't need as many protections. So that's just something to be aware of, that certain things you might assume would protect you in your living space may not protect you in your commercial business space. But the good news is that commercial leases tend to be much more negotiable than residential leases. So they tend to, the landlords who are working with the businesses know that you're going to have different needs depending on what your business is, and they're going to be much more willing to make modifications to the lease should you need them. And then the last major difference that we wanted to note was that maintenance and repair often falls much more so on the commercial tenant than it does on the residential tenant. So you might be more responsible for things like maintenance costs, pest control, stuff of that nature that in your home you would expect your landlord to take care of for you. And if anyone would like to add anything.
Oh, no, I think that's a great summary. I think the one additional takeaway I have from that, which you pointed out on the last slide, that second point about the legal protections, makes the concept of a commercial lease or contract even more important, because you can expect that most of your legal protections will be in that document, as opposed to being extra contractual remedies like you would have in a residential sense. Right? There's a lot of consumer-oriented, tenant-oriented statutes out there that even outside of a residential lease, there are protections out there. Really, in the case of a commercial lease, the four corners of the contract will really dictate the terms of the relationship between the commercial tenant and the commercial landlord. So, well done.
And I think if I can just jump in here as we just think about the times we live in and how much the commercial markets have changed in the wake of the pandemic. So if you're considering commercial space, I think you also have to consider the size of it, what you need, right? What you need today could be very different from what you would have needed in 2018, right? Or what you thought you needed in 2019. So that's something to consider. And because the market has changed, it means you could have more flexibility and leverage to negotiate with commercial landlords in a way that you might not have had 3 years ago, right? So as we think about inflation that we're all dealing with in our personal lives, and as prices change, the flip side to that can sometimes be in commercial markets that could give you some more leverage, right? But you may want to be really careful about the sizes of spaces you're considering taking on. And you may also want to push commercial landlords a bit in this market to provide more than perhaps they would previously.
Okay. I'm going to pick up briefly on employment contracts. Next slide, please. Now, most likely, maybe there's some sole proprietorships out there where, you are the only employee of your organization, but most likely, all of you out there have employees other than yourself at your business. And so you'll bump up against potential employment contracts almost every day as you're considering hiring and hiring people and perhaps dismissing people from your workforce. We have, as you see on the slide, 3 different ways a contract for employment could be created. You have a written contract, you can have an oral contract, or even an implied contract. Written contract, pretty straightforward. There's different levels of that. Often we'll see for us, in businesses where there are senior executive directors or management people, there are employment contracts which dictate not only what happens during the course of a contract, how much somebody's being paid, what their bonuses are, what their responsibilities are, but also what happens after they leave. So if they are terminated for certain reasons, they might get a severance. If they're terminated for other reasons, they might not get one. And the quid pro quo sometimes there is if you're given a severance, then there are other post-closing restrictions, like you're not allowed to compete, you're not allowed to solicit our employees, you're not allowed to disclose confidential information, you're not allowed to disparage or say bad things about people. So that's kind of the most highest form of a written employment agreement. But there are other written agreements, such as an offer letter, which in and of itself might still provide for what we'll talk about later, at-will employment, but there are promises that are made in there, such as what you're going to be paid, whether you might get a piece of the ownership, what your vacation is, certain benefits, and that can form an agreement between the employer and the employee. Oral contracts, I think we touched on it earlier, Janaki in her opening remarks. If somebody says something makes an offer to somebody, and that is accepted, and there is consideration for it, including a reliance on that promise, that can be viewed by courts as an oral contract for employment, which both sides might have some obligations underneath that oral arrangement. And last but not least, implied contracts. Even though the parties might not agree explicitly, there are provisions perhaps of employee handbooks, for example. Most good employers would want to have an employee handbook in place, which sets out certain, kind of underlying terms of practices and procedures for employment, including, for example, what happens if there's a disciplinary proceeding or if there's, a dispute and how those get resolved. Even if someone doesn't acknowledge that particular, like signing off on that as you would a traditional contract, that still could be read into the relationship between the employer and the employee and applicable to that relationship going forward. Some basic questions for employment contracts. Again, like most of the contracts we've talked about before, why do you have one? Why do you want one? Because there's some specificity that helps dictate the relationship. Job description. What are the employee's basic functions? What are you required to do? What are you not required to do? What are the expectations? And then what are the hours and work location? That's pretty straightforward. Compensation on everybody's mind. Is there clarity around how the employee is paid, how often, and what other benefits might they receive? Is there a company car? Is there cell phone allowance? If you're spending personal money for work-related obligations, whether it be taking a client out to lunch or traveling from point A to point B, how are you going to be reimbursed for that, if at all? Term of employment. This is a very important part. And if you take anything away from this section, and remember that is, in most instances, an employer will have their employees be at will. That means that as an at-will employee, that employee can be, continue to be employed, or the employment terminated for any reason or no reason. There is no commitment by the employer to any fixed term of employment that would have some consequence if that person were terminated. And so that's why you will often see in the offer letters you're either signing yourself or that you as an employer will be sending out. You'll often see you might have terms of payment, benefits, but there will be a statement in there that says that notwithstanding what this offer letter says, that you are an at-will employee, and that means you can be terminated at any time for any reason or no reason. Other conditions, is the offer of employment or offer of continued employment subject to terms like background check, drug testing, maintaining a professional license, or other criteria. So again, if you are, for example, I believe some of our attendees might be in childcare or education, right? In Pennsylvania, there are requirements that you have certain screening to make sure that you are, permitted to be in and around children in the Commonwealth. If you are, a nurse practitioner or whatnot, you have to maintain your certain license. If you're a lawyer, you have to maintain certain continuing legal education requirements. And so that would be beneficial to the employer to specify those conditions of employment at the outset, and also perhaps to keep that in your employee handbook, which I mentioned earlier. Okay. I'm passing this on to Latoya for service contracts.
I think I'm up for service agreements. I just want to touch on one point in terms of termination and at-will employment. That's absolutely right. Just keep in mind, if you're terminating someone for a reason, any reason, no reason at all, the reason it can't be discriminatory, right? So that's just an important caveat to keep in mind. If you have an employee becomes pregnant, you can't terminate them, right, for being pregnant. You can't terminate someone for being part of a protected class. You can't terminate someone for being a woman. So just keep that in mind. Termination for any reason or no reason is okay, but not for a discriminatory reason. And as we get into service agreements, so we talked about vendor agreements earlier. Service agreements are just another category of vendor agreements, and they usually apply. We can go to the next slide. Thank you. They usually apply if your vendor is providing a complex, specialized service, something over the long term. So you might see this from a media company, a PR firm, a marketing firm. And if we go to the next slide, we can talk about some service agreement provisions you typically see. Scope of work, sometimes referred to as SOWs. So this is important because it ties back to what Janaki talked about earlier in terms of the various elements of a contract. And if you remember the category she talked about called exhibits, typically in a service agreement, there'll be an exhibit that has the scope of work. And the scope of work has the specific details about the service you're buying. So upfront will be the basic contract terms and something Paul referred to as the boilerplate, kind of standard legalese, right? Legal terms. But the scope of work is really where the meat is, right? The scope of work is what you want to dive into because that will detail the service you're actually paying for and what you expect the output to be. Location of the work is going to self-explanatory. Where is it going to take place? Are you providing the facilities? Are they expected to do it off-site and deliver the final product to you? Performance benchmarks, and this is something that's important to build into the scope of work. Are they supposed to be at a certain point in the project by a certain date, right? Are there certain milestones they're supposed to hit? And how are those milestones documented? You want to keep that in mind. And we talked about waivers earlier in terms of limits of liabilities. If the vendor doesn't fully meet your expectations, depending on what they are, they will want to prevent you from coming back after them, not paying them in full.
Okay, this is Paul again, as in case you can't tell among the panel members here, and I will be talking about agreements among owners. Now, try to keep this to a reasonable level, but this is what I do on a day in and day out basis. So happy to talk about this. Many of you as business owners, again, you might be a sole proprietor or a sole owner of a business, right? You own 100% of your business, but you might have a business partner. You might have multiple business partners. And you might even be business partners with friends or other people you've known for a real long time. Very frequently, people will come to me and they'll say, I'm starting a new business and, I'm in business with, my high school classmate that I've now known for 20 years. And, we'd like to, what do I need to set it up? Right? What do I need to do? I just form a company. Okay. And I say, well, do you have an agreement between, oh no, we've known each other forever. And, we trust each other. And also we're a startup. We don't have a lot of money and we don't have a lot of money to pay you, Paul Jascott, a high priced Philadelphia lawyer, to put together some 40-page contract full of legalese and boilerplate, which I'm going to never read, or at least you wouldn't have read before you attended our seminar today. Okay. And what I say to them is like, okay, well, what happens if your business partner passes away and her husband owns half of your business because it would pass as a result of whether there's estate planning or intestacy laws. And then they each look at me and they have these furtive glances like this, they know what the answer is. Like, I would never want to be in business with that person. But they can't really say it out loud because it's your business partner's, spouse, right? So that's one example of things that why it pays to think about an agreement among owners, even at a very basic level, when you're in business with somebody else. Now, obviously, if you're a larger business, and by the way, we're talking about for-profit businesses for the most part. Latoya in a moment is going to speak about nonprofits, but for-profit businesses, it really does behoove the business owners to think about that relationship, because some of the key terms you'll have to think about, as I said, is ownership and voting rights. Who owns what? Making sure that if you think you're 50-50, you're confirming that you're 50-50, or if you're not, that you know what percentage you have. And voting rights, maybe more broadly, who controls what the business is ultimately doing. Next, operation and duties of the members and partners, having a clear understanding of who's doing what. It wouldn't be the first time that I heard a business partner when there's a dispute, because they might not have an agreement, where somebody says, I am working 24/7 and putting all time and energy into this work, and my partner isn't doing much. They show up 3 days a week. They, eat lunch, they go home. But meanwhile, I'm 50-50 with them and they're making 50% of the profit here. Dispute resolution. Okay, well, suppose that's happening and there's a dispute between, how does that get resolved? A lot of times, people will have provisions in there where they can mediate or have a third party come in and try and settle a disagreement. Other times there's arbitration, which is a more formal procedure, but it's confidential from the public. And other times, you have the ability to go to use the Philadelphia or other court systems around here to resolve that dispute if it really does rise to that level. And then, as I talked about earlier, jokingly at the start, there are events that could occur that could impact the relationship of the person to be involved or the persons to be involved, whether it be something as tragic as somebody's passing, whether it be somebody's disability, whether it be, another event that occurs in life. Maybe they face a personal bankruptcy. Maybe they're going through some changes in their personal relationships with a spouse. But overall, these are the general parameters of what goes into an agreement among the owners of a business that should be thought about at the outset. And with that, I'll kick it over to LaToya to talk about contracts for nonprofits.
Thanks so much, Paul. So obviously, we didn't want to wrap up today without talking about some things that are specific to nonprofits and things that you should be thinking about. So if we can move to the next slide. So a few types of agreements to consider. Grant agreements, program agreements, board agreements, and volunteer waivers. And so we'll take each in turn. So a grant agreement is a little different from the other types of agreements we've been talking about because it's as if an organization is giving the nonprofit a gift. Typically a gift of money, but it could be a gift of something else of value. Maybe it's a vehicle, right? Maybe it's a service van you need. One of the most important things to think about when it comes to a grant agreement is that there will likely be a condition tied to how you use the funds, right? You may have to use the funds for a particular aspect of your nonprofit mission, or you could get a grant that has a level of flexibility where you can use it for general operating funds. But typically, grants come with conditions, and you need to be careful because you often have to document how you use those funds to the foundation or the organization making the grant to you. Program agreements, these are important for nonprofits. If you put on events, if you partner with other development organizations in the neighborhood, you may want to have some terms kind of spelling out what your obligations are, what you're actually providing. Board agreements, if you have an advisory council, if you have a board of directors, when you have those board members coming on, you may want them signing a simple agreement that details their obligations, right? Their agreement and understanding that they will be asked to attend board meetings a certain number of times a year, that they're going to keep sensitive information confidential, things of that nature in terms of your board or advisory council. And finally, volunteer waivers. If you have volunteers who are stepping up to get involved in the community or do things that could be hazardous, could be potentially dangerous, right? They could come and be working on building a rec center or making repairs or what have you. You want them to sign a release and a waiver so that if something happens or if they're hurt, they won't come back after your organization. The other thing that I think is maybe a little less morbid than talking about injury is very often you want to use people's comments, their likenesses on social media, their pictures, right? You want to advertise what your organization is doing. And of course, in the world we live in, social media is an essential vehicle, right? For getting yourself out there. You may want them to sign a waiver that it's okay for you to use pictures of them in that way. And then finally, we are going to turn it over to Janaki to talk about best practices.
Thanks, Victoria. When I think about contracts, right, I really think about a prenuptial agreement. Okay, it's
Janaki, you're getting controversial.
I know,
here.
right? And the reason I think about that is whenever we get into an agreement with somebody, we are in a happy place. We want to partner with that person. We want to get into a contract. We want to do business with the person. And so we are, in our mind, nothing can ever go wrong, right? Until that divorce hits. And when the divorce hits, everything goes wrong. So lawyers came up with this brilliant idea of prenuptials, right? And we do this even though we don't want to suck the romance out of a marriage. We put the agreement in place thinking about the worst case scenario and how we can protect ourselves at that time. Every contract is like that. Because once you sign on the dotted line, most of the time, you put it on the shelf. You don't really keep referring to it every day or read it, but you do pull it off that shelf when something goes wrong. So when you think about an arrangement with anyone, the pessimist in me will tell you, think about the worst case scenario, and then think how important those factors are to you, and negotiate with the must-haves and leave aside the not so good to have, but that points that you don't really care about, right? So change your mindset when looking at a contract. Don't be in that happy space all the time, though enjoy it. Take yourself out of it into the worst case scenario, right? And the reason I say you need to do that, it is with that mindset that your contracts will become clearer, they will be more detailed, because now you're addressing issues that are important to you and important to the other side, because ultimately you want to come to a win-win stage where both sides really win. But when things go bad, you also want to win yourself, right? So keep that attitude to start with. Doesn't mean you want to sour the deal. You just want to keep that at the back of your mind, right? So make your contracts very clear and concise and as detailed as you can. All right. That's why we pay brilliant lawyers like Paul all the money we do, because we want every detail captured, right? And we don't want to miss out on a single point. Use your language consistently. Why? Why is that important, right? So in our contracts, we have a lot of defined terms. We don't want to keep using the same repetitive words again and again. So we define it in a small, little, beautiful word. And we want to keep using that. Because when you go to litigation, what happens? The other side could argue, you knew when to use the defined word when you wanted to, and here you haven't. So obviously you didn't want to use it that way, right? So you don't want to leave these kind of ambiguities in the contract. And some of us, and most lawyers, have this pet peeve. We want everything organized in a fashion. But it's not just a pet peeve. Contracts by itself are really difficult to read when you're not a lawyer, sometimes even when you are a lawyer, right? But if you have a logical story to tell, people find it easier to understand, because a contract ultimately is telling a story. It gives you the background as to why you got together, which we call as our recitals. It moves into the terms which are going to carry through with your agreement, and then it ends into how you're going to terminate it and get out of that agreement. So it is a story by itself. So when you organize it in the right fashion, you will find it easier to comprehend, okay? But, we've spoken today a lot about damages, indemnification, termination, getting out of a contract, right? But all of those are contentious positions. That's when things are going really bad. Somebody's suing you. Somebody wants to take damages from you, right? This is all in a bad case scenario. Those are the remedies. But none of us really want to go to litigation. Litigation is expensive. Nobody wants to spend their time in litigation, right? So what do you need to do in your contract so that when you do come to that bad stage, are there some easy remedies within your contract? Are there terms that you can kind of rely on? For example, if somebody does something wrong, is there a way for you to withhold the payment of their invoice? Is it a written thought in the contract so that you don't really have to worry about it, just hold on to the money, right? Or is there a way for you to say, okay, if you do this, I'm automatically out of the contract. I owe you no other obligations. So these are easy remedies that you can work with without actually going to court. Now, if somebody wants to sue you, they're going to sue you no matter what. You can't stop them from doing that. But you want to have some inherent remedies in your agreement, because sometimes termination, though it seems like the easiest remedy to get, is not really a remedy because it's impacting you adversely. So you want to have some easy remedies in there. But one of the things I've found in any contractual claim or dispute, talking to the other side is extremely helpful. Sometimes we get so caught up in egos that if you just bring it down to a regular conversation, you may actually resolve a lot of issues, right? To talk to somebody and get them or convince them to move away from a dispute, you need to really know your agreement well. You need to understand what your strengths are, what your weaknesses are, what you can argue and what you can't argue. It is only when you know that can you go in there and make points with the other side to persuade them.
Janicki, if I could jump in here, one of the just really practical considerations to think about is if you're a nonprofit, if you're a small business, and just thinking about the kinds of entities that you're going to be working with. This is why doing what us lawyers call your due diligence or your research on the party on the other side is so important. Because if you have entered into a contract with a party that does not have any resources, that does not have any assets, then you can take all of these steps, even initiating and even winning a lawsuit, right? If they don't have the assets to satisfy that judgment, the practical result is that at the end of the day, you still won't be made whole, right? So doing your due diligence on the entity you enter into a contract with, do they have assets? Is it a legitimate company? Do they have insurance? Do they have good references? So that if something does go wrong, there's something actually standing behind that entity. They have some financial wherewithal to make things right. Because Janicki makes a good point. It shouldn't progress to litigation. You should be able to have a conversation. But you can imagine if the party on the other side doesn't have any assets, they're not going to be reasonable because they can't pay you, or they may keep promising you, oh yes, sure, I'll do it, but they don't have anything. So that upfront research is really critical so that if you get here and you start to take any of these steps, you can actually get something for your efforts.
And to Latoya's point, right, there is one of the comments we have over here is tell them that you're going to take them to court, bring them to the table, right? That's such a blatant threat. People are going to go on the defensive right away and you're going to get aggression. But if you use this talking points and you try to negotiate something different for yourself that may give you an advantage over what you're losing, that's when you hedge your bets and you say, am I going to lose more by fighting here? Or am I going to lose more by just walking away? Or can I get something in between which will give me some relief, right? So keep your practical hat on, keep your ego out of the door, and try to work through this in a way that most benefits you. And to Latoya's point and the last point here, going to court and into a lawsuit is your last option. Nobody wins other than we lawyers sometimes, but nobody else wins, right? So, sorry, Paul. But truly, it's not a nice place to be, and so try to keep away from it. So we parked a thought when I was talking about purchase orders. Can you breach a purchase order? Can you cancel it? Can you terminate it, right? And purchase orders, unlike contracts, are for a specific item for a specific time. They don't go on and on and on. It's one PO to PO. And there are instances under which you can terminate your purchase order. For example, if somebody's lied to you and there's a fraud that they've committed, right? If it's something that is so unconscionable, if there's some kind of a discrimination that is going on that forced in the way they're acting on your contract. If you just kind of misunderstood, you were trying to buy a chicken and they gave you cotton candy, we just kind of completely misunderstood what you were dealing with, or because it becomes impossible to perform. Through this pandemic, a lot of people have not been able to perform what they were supposed to perform. Things shut down, right? So in situations like this, is that something you can invoke to terminate a contract or a PO? Yes, you can do all of these, but there's nothing better than a conversation. All right, so try to make it work as much as you can. And some of the quick tips: have a contract template ready for yourself so that it's a go-to item. But never forget to read your contract template when you're using it or before you use it to make sure that's absolutely applicable to what you're doing. because templates are forms written by people who are not addressing every fact pattern in your life. They're not a crystal ball, right? So you need to be able to make sure that they actually apply, or do you need to change them a little? And that's why you come to update your contracts regularly, right? And you want to at least understand, if I'm using this form for a vendor, is everything this vendor is doing for me captured in this? Is the statement of work at the back absolutely accurate for the job that they're going to do? You know, and just read it casually, but read it. Don't just walk with it. And most of the time, you know, contracts do need lawyers. You need some guidance. It's not an easy document to navigate, but also lawyers can help you strategize your negotiations. They just don't write the document for you. They can tell you different approaches to get to the same place you want to be in your mind, accomplish your goals within the contract, right? So these are our tips to you for working through your contracts. Are we taking questions?
Thank you
Thanks.
all. So as I said in the chat, you can type your questions to me in the chat now, and I'll read them out loud. I'll start by opening the floor up to the folks we have with us in person. If you have any specific questions for our panelists.
I was just listening. So when you talk about having a contract and you want to work with a small business, sometimes you see the small businesses online like Instagram and things like that. It's a small business, you're asking for something big. How do you protect yourself with that? Because you're asking for something big, you kind of see them what they're doing, but you really don't know what's happening. But you know you see them, but to do your labor behind it, kind of know they don't have anything, but yet you want to give them a chance. How does that work?
So I love a good pilot program. I'm a fan of a pilot. So if you're looking online and you're identifying a small business that you want to give a chance to, you're identifying a woman-owned business, maybe it's a minority-owned business, and you feel compelled, right, to give them a break, start really small. Right. So it's not a question of whether or not this small business owner can take on my big job to start. Can they really do it? Because all you're doing is setting yourself up and them up for heartbreak. So carve off a little sliver of what it is you need, and you can try it that way once you do your research to make sure they're actually legitimate. Right. And also think about whatever small task I'm going to give them to do. We're going to see how this works. Make sure you have your contingency plan. What's your backup if they don't follow through, right? And if you start small, then over time you develop a relationship, you develop, you can see what their capabilities are, and then you can really grow the relationship over time so that if you end up working with this small business you've identified on Instagram or other social media, they start to develop and grow. And now you have this sort of long-term relationship and will likely have more favorable terms because you were there to help them and support them in the beginning. But I would say start small. Don't give them a big thing, because then you could very likely end up disappointed and without an avenue if they don't have enough assets to cover the breach, or they can just ghost you, right? They can just they can just disappear. So I would say start really small, see how they do, and then go from there.
Thank you. I have one question. I attended another network event, and under there, who deals with employee payrolls, was discussing that there was some legislation coming out regarding really defining contractors. My business really deals with subcontracting a lot of services, and how the IRS is kind of categorizing contractors going forward to make it a little bit more difficult for employers to define contract versus employee. Do you have any advice or any knowledge about that?
Who wants to take this one, Paul?
Yeah, the first honest answer is I don't have any specific knowledge about that tax legislation that's pending, but you do raise, and I should repeat the question. The question from the audience here related to some potential pending tax legislation that related to the proper classification of an employee versus an independent contractor. So as I said, I don't I don't have specific knowledge of that. We're fortunate here at Holland Knight that we have, I don't know, probably 300 tax lawyers that probably know about that. So I can certainly get some information as a follow-up to this. We make it available to everybody about what might be coming out or what we see coming out. But the point you raise is an excellent one in that I talked earlier about employee contracts, and that's with somebody who is in fact your employee. Sometimes it's a gray area. And why is that important? Because there's different obligations to taxing authorities, among other things, for withholding tax. If you're an employee, if you were an employer and you have an employee, you have to withhold tax and actually pay that directly to the government, whereas independent contractors get 1099 and are responsible for paying their own taxes. And that's separate and apart from the other type of legal protections or requirements that would apply to an employee-employer relationship. So, so to answer your specific question, I don't know, but I can find out. But then there are a number of different characteristics. I think there's almost like 20 of them that help define whether a person who is providing services to a company falls into the category of independent contractor versus employee. And honestly, as you say, it's a tricky area that requires, really some legal analysis to help avoid tricks there.
If I can jump in on this one. So this has been building for quite some time across a number of regulations have been tightening in terms of how you categorize a contractor versus an employee for various reasons. So one has to do with the kind of benefits and support that you provide to employees that contractors don't receive. So a lot of what we're seeing, I think, in the labor movement has been, and you may see this in the areas of people who provide transportation services for Uber, for Lyft, people who are providing services for various delivery services. We saw this a lot. There is an advocacy movement to say, well, wait a minute, these folks aren't contractors. These companies are just calling them contractors because they don't want to provide the benefits that you should when you have an employee. One of the things, and I mean, as Paul mentioned, there's about 20 different criteria to look at in terms of an employee and a contractor. But one of the most significant ones has to do with whether you direct their work or they direct their own work. So we talked about service agreements earlier. If someone is a contractor, then their relationship is more akin to what you would see in a service agreement. You tell me what you need, I direct my work, I direct my time, I direct how it gets done, and I provide it to you on X date, or I provide it to you periodically, as opposed to you controlling their work, right? That's a sort of a big warning sign that someone is not actually a contractor, but an employee.
Just a follow-up to that, because I typically have those provisions in my contracts for contractors. I was wondering, and maybe you can just send this into like as a follow-up to like maybe new provisions or new categories that they're asking to make sure that particular clause is very clearly defined in the independent contractor agreement when doing contracts with contractors. I guess it's not a question, that's just more like a request.
So you can sign up also for alerts, sort of a local chamber of commerce. You can sign up for various mailing lists with regulatory agencies that do this. So that way something hits your inbox when there are changes in this area.
You're welcome.
So I'm trying to get some clarification on one of the questions you have in the chat, but in the meantime, I wanted to ask if you all could maybe expand upon the idea of force majeure clauses in contracts and how they would apply across all the different types of agreements that you talked about today, because you talked about many different types of contracts. And I know force majeure clauses became a hot topic in 2020 when folks were not able to fulfill the terms of their contracts. So I was hoping you guys could elaborate a little bit on that.
Janaki?
Sure. Why not? You are right. They did become a hot topic when COVID hit everyone, right? And people couldn't do what they were supposed to do. there was some discussion in the early stages where whether the pandemic is a force majeure because people were working, right? But the government orders were forcing people to stop working, not open their shop. So there was some argument at that time. Very quickly, the definition of force majeure has changed. People have started adding pandemics into that, and people say it is a force majeure. Force majeure basically means you suspend work for a little bit of time, right? It doesn't mean you're terminating the contract. It means you're allowed to suspend your obligation because there's things beyond your control that excuse your performance of the contract, right? After a period of time, you are allowed to terminate it because situation can't keep going on. Sometimes it's 30 days, sometimes it's 60 days. It depends on how you negotiate it. But some of the new trends we're seeing is now because of these cyber attacks and people's fear about the banks, money getting blocked. We're seeing not only is an obligation to perform a service or sell a product being suspended, but people are requesting their obligation to pay also be suspended, because what happens if there's a cyber attack? What happens if we can't get money out of our banks, right? So it's an evolving field right now, but generally it means things beyond your control, right? Originally, when force majeure started, it was acts of God, and acts of God were considered things beyond your control. Somehow the trend has been recently to make it a little bit different. It says acts of God, things beyond our control, including acts of God, which brings a really big bucket. And when you get a clause like that, you want to be careful, because it could mean that they're not getting raw materials. It could mean that, they feel like there's a hurricane or something. Hurricane would be the act of God, but not getting raw material is not an act of God, right? They should have had a second source. They should have known where to get their products from. So when phrased in the latter form, you want to be more questioning. What does this mean? What other things could happen? Because we only want acts of God to come in it. But then there's war. That's not an act of God, right? Then there is government action. That's not an act of God. So things have been tagged onto force majeure, and they're becoming bigger and bigger as clauses. But again, force majeure should not be used lightly. It impacts your credibility. You don't want to just throw it out there. It's also not specific to one customer or one vendor. It is situation at large. So you want to be careful what message you're sending out to the world.
Great, thank you.
Mm-hmm.
So yeah, still waiting for more clarification on this question in the chat, but I want to invite folks to, unmute yourself one at a time, please, or continue to type things in the chat. Have time for a couple more questions, because I know that our presentation was packed full of information. So I want to make sure that if people had burning questions, they're able to get them out. Or you can always follow up with us, the email address on your screen. If you want to send your questions in there, we can try to have them answered after the event. Again, we'll be following up with participants who need specific contract advice on their own business contracts, but just want to leave the floor open for a couple more minutes in case anyone else has a question they'd like to ask our panelists right now. Maybe we can try to parse out what this person is trying to ask, because I haven't heard back. They asked, how would I implement this? Now, this is the question I'm wanting clarification on. I sell business and consumer insurance, and my rates are pre-approved by the states that I'm licensed in. So I'm trying to figure out what this is exactly, if it's a particular part of a contract or contracts in general that they're looking to implement, and trying to figure out how to do that when their rates are already preset for them. Maybe that's the question.
You said business and consumer?
Yeah, sell business and consumer insurance.
Yeah, I guess, and I appreciate the request for clarification. I don't know if it's a concern about the negotiation of those provisions, or perhaps it's a clause in there that you can't set it, for whatever the term might be, that it's subject to rate increases, that rate changes, if you will, that are again beyond his his or her control there. So, I think in either instance, it's providing that clarity as part of the contract, whether it's in a pricing exhibit or whether it's in the term, that prices are subject to change. And I guess as I think about the give and take between the provider, the vendor and the recipient of it, I can see if I was on the other side of that contract being concerned about, fear of the unknown. Okay, you're telling me my rate today is $100 and you're telling me you have to charge me a certain rate that's dictated to you. But suppose it goes from $100 to $200 and I know I can only afford, $125. Then if I were the counterparty to that agreement, I would then have to say, okay, I understand that. I accept that potential risk of a price increase. However, it can't be an unlimited price increase, and I need a provision in my document that protects me against the risk of a high price increase. And so I should have a termination right after some period of time when this price changes. If I can't afford it or I can't otherwise perform, that I have a termination right so I can get out of the contract. So I have a choice. Either pay the 200 or terminate the contract and find this insurance product somewhere else.
May I just jump in over here, right? So this, besides the question asked, this is like a real thing in today's world, right? Vendors are increasing prices. You have to sell it to your customers and you have a fixed price agreement with your customers over time, right? So what do? You're getting caught in the middle. And the question from the business is always, can we change our price? Can we increase our price? The customer is saying no, right? There are different scenarios under which you could deal with this. There can be a very aggressive position you take. Hey, the world is blowing up. I'm not a not for profit. I'm a for profit. And I need to increase my price to sustain myself. So I'm going to do it. I'm not selling you if you don't take my price. Sometimes that works. Sometimes the customer pushes back. But that's your time to start negotiating with the customer and saying, hey, the world is in a bad place right now. If you're going to work with us today to do this, tomorrow we'll work with you better on something else, right? So you can partner. So you could have a very friendly approach or you could have a very aggressive approach depending on the facts and your relationship. But this is a real concern, not just in the insurance world or the rates, it's in every buy and sell that we're doing, right? We are tied into contracts that are fixed price, and how do we navigate those?
Thank you so much. So I'm going to take the absence of questions as a compliment. That means that you guys covered so much in this presentation that everyone is walking away super confident when approaching their next contract. So thank you all again for your time and your wisdom. This was wonderful. We will be sharing the presentation for those of us who couldn't make it in this heat wave today. We do appreciate our, people who have joined us in person as well as virtually today. Thank you for sticking with us for today's session. I know it's been a long day and a long hour and a half here. So again, I hope you have a great rest of your day. I'll be following up with you tomorrow. And we hope to see you back here in one of our next workshop events. And have a great rest of your day. Take care, everybody.
Thank you.
Thank you, everybody.